Get ready. 3 seconds. 2 seconds. Start. On 5/5/2008, a girl aged about 6 years went out of her house at 9 p.m. When she did not return for half an hour and was not successful in tracing her, he filed a missing report at police station. On 11/5/2008, respondent number 5 informed him that his daughter has been kidnapped and kept under unlawful confinement by respondent number 6 to 13. The respondent police did not take any action on his complaint. Aggrieved by the inaction of the local police, he made a representation on 3/6/2008 to the senior superintendent of police. On the directions of the superintendent of police, police station registered first information report (FIR) number 484 dated 6/6/2008 under sections 363/366/506/120B IPC against the private respondents. Even after registration of the FIR against the private respondents, the police did not take any action to trace the girl. According to the allegation he was asked to pay money for initiating investigation and to arrest the accused persons. Ultimately, the petitioner filed this petition under Article 32 of the Constitution before this court. This court also issued notice to the Learned Attorney General for India to assist the court in this matter of general public importance. The Learned Additional Solicitor General submitted that the issue, which has been referred to this court, has been decided by a 3-judge bench of this court in Alek Padamsi versus Union of India 2007 6 SCC 171. In this case, this court, while referring to the judgment in Ramesh Kumari versus State 2006 2 SCC 677, in para 2 of the judgment has been observed as under: whenever cognizable offense is disclosed, the police officials are bound to register the same, and in case it is not done, directions to register the same can be given. Whenever any information is received by the police about the alleged commission of offense, which is a cognizable one, there is a duty to register the FIR. It was submitted on behalf of the Union of India that Section 154 (1) provides that every information relating to the commission of the cognizable offense, if given orally to an officer in charge of a police station, shall be reduced in writing by him or under his direction. The provision is mandatory. In case such information is given in writing or is reduced in writing on being given orally, it is required to be signed by the persons giving it. It is further provided that the substance of commission of a cognizable offense as given in writing or reduced to writing shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. Subsection (2) provides that a copy of such information as recorded in subsection (1) shall be given forthwith free of cost to the informant. He suggested the following measures: 1. The police officer must record the complaint in the station / general diary. This will ensure that there is no scope for manipulation, and if subsequently he decides to register an FIR, the entry in station/general diary should be considered as the FIR. He should immediately report the matter to the superior police officer and convey him his reasons or apprehensions and take his permission for deferring the registration. A brief note of this should be recorded in the station diary. Some guidelines can be framed as regards registration or non-registration of an FIR. According to him, some such guidelines are as follows. Number 1. Normally, in the ordinary course, a police officer should record an FIR if the complaint discloses a cognizable offense. However, in exceptional cases where the police officer has reason to suspect that the complaint is motivated on account of personal or political rivalry, he may defer recording of the FIR and take a decision after preliminary inquiry. Number 2. The police officer may also defer recording of an FIR if he feels that the complainant is acting under a mistaken belief. Number 3. The police officer may also defer registering an FIR if he finds that the facts stated in the complaint are complex and complicated, as would be in respect of some offenses having financial contents like criminal breach of trust, cheating, etc.